Guess you did your paperwork while you're standing, so it looks like we're ready. It's my understanding Mr. Reasoner will be arguing? Yes, Your Honor. You may proceed.
Thank you, Justices and Counsel. Will Reasoner here for Ms. Linda Juckette. The franchise granted to Mid-American by the IUB must be reversed because the fundamental predicate of the proceeding in the IUB's decision is based on an unlawful and incorrect reliance on Section 306.46. The IUB's order granting the franchise was explicitly premised on the IUB's incorrect application of 306.46. The order addressing the arguments about that statute, the IUB said, the lack of all necessary easements will serve as a basis to deny Mid-American's request for a franchise. And regardless of what the IUB said about application of 306.46, Mid-American, in order to obtain a franchise, was required to show that its route did not unnecessarily interfere with private property, and Mid-American was required to show that it actually considered alternative routes. And in doing so, what Mid-American presented throughout the whole evidentiary hearing to the IUB was a matrix. And this matrix was made up of ranked data points on all these different routes. All of the data that went into this matrix was based on cost of number of poles, cost of turns, and most importantly, cost of land acquisition. Now, Mid-American, throughout the whole proceeding, maintained that it could enter right-of-ways on individuals' properties for free without any compensation. So all of the information that Mid-American relied upon in presenting its evidence to the IUB on why this is a good route and why this does not unnecessarily interfere with private property was based on the faulty premise that 306.46 allows Mid-American to enter rights-of-way. We're not talking about just Linda Juckette's right-of-way. We're talking about right-of-way on all properties for all routes Mid-American considered.
46. When is the event of consequence that we talked about in the Herbeck or Raybeck case, however you say it?
Consequence has to be the substantive action of when a utility pole or a utility infrastructure is going to be placed in a right-of-way. The action that matters in terms of 306.46 cannot be the predicate grant of a right-of-way. In this case, the right-of-way was granted in 1979. 306.46 was enacted in 2004. This franchise that was granted in early 2021 then says that the right-of-way, which was granted 25 years before a statute was enacted, actually carried with it an extra stick in the bundle that was not granted back in 1979. All that was granted in 1979 was a road right-of-way. And what 306.46 tries to do, or what the IUB does with 306.46 is say, no, at the time, 25 years before the statute was enacted, you actually gave a second stick in the bundle. That second stick was a utility grant.
Retroactivity analysis matter? I think the board said, however you want to frame it, retroactive, prospective, if your claim is a taking, you're looking at the conduct that's occurring now, right? I mean, in some sense, they're right. Because of it, it's a taking claim, or at least there's an argument that this is a taking of some sort. It doesn't really matter in terms of whether it's retrospective or not. The analysis is the same.
Granted that I believe it's the court's preference to not address constitutional issues if you can look at other issues, but I think I agree wholeheartedly with what you're saying, that regardless of how you look at this, the legislature is attempting to mandate that when a right-of-way is granted, that it always carries with it an extra stick in the bundle. We're not looking at an easement that would be granted post-2004, but I think that that still would be an unconstitutional taking if the legislature is saying that a utility can be placed in a road right-of-way.
Amici here mentions the fact that since this statute was changed in 2004, there's obviously been a lot of construction that's gone on since then of putting up utility poles and other things. what happens if we were to rule in your favor in this case? Would we be unwinding all of the reliance on 306.46 since 2004 in cases that maybe weren't challenged, but they looked at this and said, well, it looks like they can do this and it's not something that we get compensated for?
I certainly don't think so. First of all, there is a statute of limitations for bringing an action for trespass or damage to property, and I think that that's what that sort of hypothetical would be asking for. And I believe that that would be a 5-year statute of limitations, so we're going to look at 5 years back from now. Additionally, it's not going to unwind the placement of poles. It would be an action in the district court for essentially an inverse condemnation action. The whoever owns that right-of-way would say, hey, this was placed here without any compensation to me. This is a physical intrusion, just like in the Loretto case, and then it would be an action for inverse condemnation, and then there'd be an analysis of, okay, what's the damage, what's the loss of value here?
What relevance does it have that there is a petition before IUB for eminent domain authority? I understand that there was a request to have the case remanded to resolve that. What relevance does that have in terms of whether or not the franchise should have been granted?
So it's what I was explaining at the beginning. It's almost the way that I'm viewing it. It's the fruit of the poisonous tree sort of analysis. All of the information that was presented to the IUB on why this route does not unnecessarily interfere with private property and why this route is the proper route to go forward was based on the understanding that Mid-American had that they could invade these rights of way without compensation. And so if this court were to say, Ms. Juckette, you're correct, 306.46 does not allow placement of utility poles without compensation, but then Mid-American would be able to obtain the franchise that was granted, premised explicitly by the IUB on the use of 306.46. As Mr. Lance said a couple arguments ago, it infects the whole decision here. So long way of saying, I think that it's irrelevant that there's been a subsequent petition for use of eminent domain by Mid-American because the franchise that was granted was predicated on misapplication or an unlawful reading of 306.46.
Are you seeking exactly?
Reversal of the grant of the franchise, which would essentially, Mid-American could repetition for a new franchise, but we'd have to proceed under the understanding that you can't invade a person's private property under 306.46 without compensation. So it's reversal of the grant of the franchise.
Difference that it's a Microsoft server farm as opposed to a private residence that they're running power out to?
Yes, well, it doesn't make a difference for the analysis of 306.46. That does not matter. But in terms, another reason why the franchise should be reversed is because under the statute to obtain a franchise, Mid-American needed to prove that this line was necessary for a public use. And so that's the first part of the arguments that you saw in the brief. And I want to emphasize that I guess there's really two issues for this court to decide. Was it a public use? We contend not. But if it was a public use, was this line necessary for a public use? And I think that the way that the IUB has treated this, it's almost a rubber stamp based on some prior cases from this court where IUB is now saying, okay, if you're asking for an electric line is automatically necessary for public use. I think that renders the statute meaningless. There needs to be some analysis here on whether what is presented to the IUB for a franchise actually is necessary for a public use. And I think that we need some clarification from this court on what that means. Is it because you're running electricity that it's automatically necessary for public use, or does it truly mean something else? And if this court does believe that it means something else, Again, we posit that it should be analogous to the public use analysis for issues of eminent domain. But if the court says it's something else, we need to send it back to the IUB then, in that instance, for analysis and application of the facts to that new law.
Go back to the kind of property right issue. So I think we could agree that the state can regulate and define property. Do we agree on that at least?
As the regulation does not remove a property right, I think the first part of what you said, I think the state can define property.
If we have older cases, for example, that say utilities can put utilities in rights of way, which I think was the understanding of our cases until Keokuk Junction. If that's right, and then the legislature passes a statute, what is the property right at issue as expressed in the plat map and creating the right of way? And even if maybe she did have some sort of right as expressed in Keokuk Junction, why does this statute go too far and affect some sort of taking if Mid-American were actually to exercise the franchise, as opposed to just a reasonable definition of right-of-way? It's a horrible question, but I'm trying to muddle through this, okay?
I think that what you're getting at is, have our cases treated utility usage in a right-of-way as an incidental use of a grant of a right-of-way? Maybe that's not what you're asking, but
Part of it, right, which is that when we're talking about the infringement on a property right or the taking of a property right, we are looking at a real world kind of issue about what is the additional burden imposed on the property by the statute or the regulation. So Loretto says, well, if the ordinance requires somebody to come on your property and put a cable box in, that's a physical taking. Here, this seems a little bit different to me, and I guess I just want to explore that with you more.
the first premise that you said there about prior case law, in Keokuk Junction, so that case was decided in 2000. In Keokuk Junction, at page 358, this is towards the end of this court's analysis on why the court is saying utilities are not incidental to right-of-ways. The court says, the more recent Iowa case of Hagenson v. United Telephone contains some pertinent dicta. That was about laying electric wires in an easement next to a right-of-way. The last sentence in that paragraph says, this case suggests in dicta that if an easement had existed, it would have only authorized activities related to travel on the road. That Let
me pause you there. After the legislature passed this statute, and it seems to be the legislature saying that incidental it is, right? I mean, that kind of is how one could read 306.46. And they're saying that as sort of a legislative matter, that as a public policy matter, we're finding that it is. Why is it, and you might disagree with that, but if that proposition is right, why is it for this court to undo that?
I disagree that that's what the legislature did, and even if the legislature intended to do that, by statute, just because it's the legislature's policy desire, you can't then just legislate out a property right. The right to exclude, Justice McDonald, I think is a right that I was going to respond to. That is what is taken here. It's the right to exclude the United States Supreme Court has recognized. That's the sine qua non of property rights. It is an important stick in the bundle of rights. And so the legislature saying, hey, we might want to undo this, I don't think the legislature expressed its intent. I mean, if we're going to look at what the words of the statute say, the words of the statute do not clearly do anything to say utility usage is in fact an incidental use to a right-of-way. At most, it's a policy statement about rights-of-ways being used for utilities, but I do want to make...
Right to exclude now. I mean, it seems like a right-of-way is a different kind of property and a different kind of property interest. A person who has a right-of-way running through their property doesn't have the right to exclude people from using the right-of-way.
They have the right to exclude these giant transmission poles and these giant transmission lines going across their property.
Your argument is assuming the answer to the question. I mean, and maybe we both are, and somebody has to decide. So I guess the question is it us or is it the legislature?
I think that when we're talking, may I proceed with my answer? When we're talking about a right-of-way that was granted in 1979, a law in 2004 cannot dictate what sticks in the bundle were taken from that bundle and conveyed 25 years in the past.
Law at the time that right-of-way easements contain the right for utilities.
That's the Hagginson case. That's from 1973. And so the state of the law in Iowa in 1973 was that right-of-ways are authorized for activities related to travel on the road only.
For a case that says installation of utilities did not burden the Servian estate to a greater extent than was contemplated at the time of the creation of the easement. And then it goes on to explain why utilities are not really additional burdens on right-of-way. So at least as late as 1994, that was the state of the law. Maybe we have conflicting cases. If that's true, then what's the implication?
I think the implication there would be that we need to look at what the state of the law was in 1979 when the easement was granted. Thank you, Your Honors.
It's my understanding, Diana Makar, am I pronouncing it correctly? Yes. Okay. And you will split your time with Mr. Magner? Okay, you two are going to have to play rock, paper, scissors and figure it out. All right.
Out. Thank you. Good afternoon. Counsel, may it please the court. I'm Diana Makar, representing the Iowa Utilities Board. I will be sharing my time with Counsel Mr. Magner for the Mid-America Energy Company. We framed two issues for your review today. With the first, I will outline how the board's decision, specifically its finding regarding the section 478.4 prerequisite for public use element, is supported by substantial evidence in the law. For the second, Mr. Magner will address how Iowa Code section 306.46 provides Mid-America with the right to install utility facilities in the public right-of-way adjoining Ms. Juckette's property. Now, there is two issues that I just want to address quickly before going to the Chapter 478 prerequisites. I believe I heard counsel for Ms. Juckette state somehow that eminent domain is tied to a franchise, that you have to have the eminent domain in order to get the franchise. And that's just simply not right. If you look at section 478.15, it states that any person, company, or corporation having secured a franchise as provided in this chapter shall thereupon be vested with the right of eminent domain to the extent as the Utilities Board may approve, provide, or prescribe and find to be necessary. So those are two separate analyses. In this case, Mid-America did not seek the right of eminent domain, so it's not at issue and does not affect the franchise. Also, I believe counsel had talked about public use that's necessary and then public use itself, as if those were two different findings by the board, and that's just not right.
Doesn't the petition for the franchise, doesn't have to specify whether eminent domain is required? And if so, doesn't it have to specify what properties eminent domain is needed for?
In this case, Mid-America did not seek eminent domain with respect to Ms. Juckette's property. What's not required is a showing that the petitioner owns the property at interest. I believe the district court even acknowledged that nowhere in the chapter nor in the administrative rules is that a requirement.
Just a mistake by the administrative agency when they, as counsel said, said that if Ms. Juckette is correct in her argument that Mid-American lacks the easements necessary for Route 7, then the lack of necessary easements will serve as a basis to deny Mid-American's request for franchise.
I believe that was addressed in the board's order on the motion for reconsideration. The franchise stands in and of itself. And if, for example, this court determined that Section 306.46 did not give Mid-America the right to install utility facilities on the property, on the public right-of-way, then that could be remanded and a determination on eminent domain be completed or undertaken by the board. Thank you. Just to give you an overview of what is required before the...
An additional question. So counsel for Ms. Juckette says that all of the board's findings are necessarily tainted by its incorrect view of 306.46, that all of the cost analysis was wrong. Can you respond to that, please?
I would disagree with that because that was an objection that Ms. Juckette had made as to another part of the analysis, and the board had reviewed the evidence in the record and determined that did not sustain Ms. Juckette's objection. Well, let me...
He's saying is that the cost analysis is just fundamentally flawed because it doesn't price into the grid the cost of acquiring these additional utility rights of way.
Actually, a part of the analysis is under 478.18 and 478.3, and there's 8 factors that have to be met under 478.3A, and in this case, those were met. I know at one point she had mentioned future valuation, but that's not a consideration. So in part, indirectly, some of her claims that overlap, if you will, with Section 306.46, her claims there may overlap, but we submit that she's waived any challenge to anything other than the public use element contained in 478.3, or excuse me, 478.4. So in the analysis for a franchise, and again, separate from eminent domain, is under Section 478.4, the board must make a finding that the proposed line or lines, 1, is necessary to serve a public use, and 2, represents a reasonable relationship to an overall plan of transmitting electricity in the public interest. If these 2 elements, public use and overall plan, are established, then petitioner has demonstrated the need for the proposed line. Next, the location must meet Section 478.18 requirements. When the petitioner establishes these prerequisites, as Mid-America did in this case, then the board must issue a franchise. On appeal, Juckette challenges the board's analysis of the public use element and has waived any challenge to any of the other prerequisites. She erroneously contends that the board should apply a constitutional takings analysis to its finding of the public use element. And the most fatal flaw to her argument on public use is that it ignores the board's application of established case law to a record of substantial evidence on this issue. First, Juckette ignores established case law on this issue. In making its finding, the board correctly cited and followed relevant case law. As set out in the board's decision, this included this court's interpretation of public use in Southeast Iowa Co-op, that the transmission of electricity to the public constitutes a public use as contemplated by section 478.4. The board also set out and followed examples in the Fisher case and Bradley case by the Iowa Supreme Court, Court of Appeals in Bradley, where certain factors were examined and factors granted by the board were upheld. Second, Juckette ignores the record. On public use, Mid-America presented substantial evidence to the board. Applying the well-settled law to the record, the board determined the evidence demonstrated Mid-American's proposed project is necessary to, 1, meet current and future transmission needs, 2, to increase system reliability and flexibility, and 3, to support current and anticipated load growth. Consistent with the established case law, the board concluded the proposed line is necessary to serve a public use. Juckette is just simply incorrect in asserting that public use requires a constitutional analysis akin to an eminent domain analysis when this court has stated otherwise. The district court rejected Juckette's arguments and concluded substantial evidence supported the board's findings on the section 478.4 elements and section 478.8 requirements. The court also determined that section 306.34 allows Mid-America's construction, operation, repair, and maintenance of the transmission line in the public right-of-way at issue.
I have some questions on the 306.46 part. Can I ask those? Can I ask one to you, or are you dividing those?
In fact, my time's just about ended, so I am going to defer to Mr. Magner respectfully. For all these reasons, the Utilities Board respectfully requests this court affirm its decision in granting the franchise to Mid-America. Thank you.
May it please the court, counsel. Let me begin with a handful of corrections to the record here this morning. So one of the allegations you heard from Appellant's counsel is that Section 306.46 actually is a relevant component to the board's evaluation of whether or not a franchise should be granted. That is fundamentally incorrect. Under Chapter 474, or 478, Section 4, the board has to answer a two-part test, whether the line is necessary to serve a public use and whether or not that line represents a reasonable relationship to an overall plan of transmitting electricity in the public interest. The need element, the need necessary for public use, is a very low threshold. That is because the large portion of the siting and additional desire to avoid unnecessary duplication or cost comes in the second component of that test.
Of that argument then, that we don't, does that mean we don't have to address the 306.46 issue? And if not, should we? Isn't there a petition for eminent domain pending?
It does, I will answer the two questions. It means that the 306.46 question is not part of the court's consideration of whether or not the franchise was appropriately granted. What the 306.46 question does is offer the court the opportunity to consider whether or not Mid-American would have to go back for eminent domain under 478.15. You also heard from Appellant's counsel, sorry.
Early presented in this case, although it's your position, it doesn't have any bearing on the validity of the franchise because the statute and the regs govern what has to, the showing required for that. Correct.
Correct. And what that means is that if this court were to say affirm the grant of franchise and find that 30646 does not represent a taking, which has been Mid-American's position under the Borman test, then Mid-American would be able to build immediately without any additional need for eminent domain authority. The second part that's been brought up that's related to this first is the discussion that 30646 or the analysis presented by Mid-American at hearing are fundamentally flawed and tied together. That is factually incorrect. When the element of the statute that Mid-American has to prove with the route study is that the utility has appropriately considered alternative routes as part of a proposal for a single route. In this case, that element comes in Chapter 478, Section 3. I will note that Juckette's counsel has not identified the appropriate standard of review and has not identified that this should be considered a separate issue from the public use standard. And we would argue that it has been waived. To the extent that this court finds it has not been waived, I would note that under this approach, Mid-American proposes a matrix where we consider not specific cost factors, which are not one of the elements of the statutory requirement that Mid-American must show, but simply an evaluation of how the line relates to the properties, the communities, and the future uses where those lines would sit. And it's to go to that reasonable relationship. The board, sitting as the decision maker in this case, has to decide or determine that the line represents a reasonable relationship to that overall plan of transmitting electricity to avoid duplication.
Maybe flipping back to a little different issue on 306.46. Your friends on the other side argue that the date that we should really be looking at is 1979 when this easement was entered into. And anything after that would change the deal that they thought that they had entered into and would constitute a taking. Why are they wrong?
So, and I will note I will be running out of time, thank you. So I would note that this position is fundamentally incorrect for a few reasons. And it really comes back to, it doesn't articulate why this is a taking under the Borman test. This court in Borman found that when looking at a challenge to a taking, the court must first find, one, that there is a recognized property right or right which has been taken, two, or that is in question, two, that right is actually taken. Yes.
Piece together a little bit. So one, we agree there is a property right as defined in Keokuk Junction. Yes? Okay.
Understand to be the right to exclude is the claim that Juckette has presented. The right to exclude utilities from the public road right-of-way.
Recognizing Keokuk Junction. Okay.
So the second question then goes to, is this actually a taking? And there are two per se takings, a permanent physical invasion of the space, which is what the court identified in Loretto, or a complete deprivation of all economically beneficial action. No one has raised the second one, and Mid-American would note that to the extent the first one may be implicated, these are not permanent physical invasions. Mid-American takes no independent, or any utility really, takes no independent right to remain in that public road right-of-way beyond the scope of the original easement, and that particular franchise from the Utilities Board has a finite, definite end of 25 years, at which point they have to go back and reseek it.
For 25 years, there's going to be large utility poles on her property. I mean, that strikes me as satisfying that prong. Am I wrong about that?
Really did focus exclusively on the permanence of that physical invasion. In the Loretto case, what you were looking at is the permanent presence of these rights, which, and I would note a primary distinction in Loretto is that the government never had a property interest in those apartment buildings that the permitted intrusion would be considered incidental to, but these are not permanent. I mean, a perfect example of...
If somebody would pull a big old dump truck in front of your house and say, we'll come get it in 25 years, you don't think that's permanent?
What I would point out is that it's...
Like a big old dump truck.
Point out that the factual record in this case demonstrates how unpermanent these are. There was an additional transmission line which was placed on the south edge of Ms. Juckette's property in 2006. As part of this particular case, Mid-American is seeking to remove that line because the grid changes.
Court's most recent case involving the statute authorizing unions to go into a farm field. And there you have a physical invasion of several hours at most. Why isn't this case worse than that case? And there they found a physical taking.
There the court found a physical taking specifically because the government, again, had no incidental use, correct? There was a discussion that, or I apologize, I believe that the actual appropriate standard in that case comes down to the right to exclude. And what I would note, and as you've already asked today, the right to exclude is no longer with the appellant in this case. As somebody who has granted that right, or more accurately, her predecessor in interest has granted a right to the state to be the party in possession and to make an ultimate determination of exclusion. That is the entirety of Iowa Code Chapter 318, which sets forth what specific actions may be permissible in a public road right-of-way and enables, and then additionally enables the state or the highway authority to expel people and things which violate that term and to seek nuisance criminal charges against them. So the right to exclude is there.
Saying you think Keokuk Junction was wrong? I mean, Keokuk Junction said that given the right of exclusion that's already lost by the public right-of-way, there's still some incidental property right that's lost by allowing utilities on it, which seems to imply that there's also a right to exclude utilities.
And I would argue that it's not that I necessarily find Keokuk Junction wrong, it's that the legislature has found that Keokuk Junction is wrong. And so at the time of Keokuk Junction, this court was asked to answer the question of whether or not a utility structure creates an additional servitude without the benefit of language from the legislature. And even pointed that out when discussing, oh, yes.
Doesn't that get us back to this timing question of when this triggers, prospective versus retroactive, I guess?
I don't believe so. I believe that first of all, when looking at the statutes, the court is to presume that the statute is to be constitutional. To get to the question that is impermissibly retroactive, the court must first conclude, contrary to Herbeck, or however you pronounce it, that the actual conduct that is being regulated is the underlying easement, and then say that the placement of utility poles, which again is literally the verb in that statute, the only way to read it would be to place utility poles after 2004. What that asks the court to do is to effectively assume or presume that the statute meant to be retroactive instead of Mid-American's position, which is at the time of passage forward, utilities may place poles.
Okay, I think we've gone over quite a bit. Any further questions from the bench? Thank you, sir.
Quote, to begin with, we have held that a physical appropriation is a taking, whether it is permanent or temporary. That's from Cedar Point Nursery from the United States Supreme Court 2021. And I believe that's the Union case, Justice McDonald. There's on this takings issue, there's two, I think there's two distinct things that you need to decide. I suppose there's more, but there's really two at the forefront. Is utility usage in a right-of-way incidental to a road right-of-way? And then if it is not incidental, is there a taking by the placement of the utility poles? I don't think we can conflate these two. So we need to know whether or not utility usage is incidental to a road right-of-way. Keokuk Junction says it is not incidental. In the Iowa case,
It relied on the fact there wasn't a statutory authorization, so then the legislature stepped up and enacted the statute to provide that authorization. Can we consider that statute to be a curative act that would resolve, or that's another way to resolve the timing issue under cases like Zaber versus City of Dubuque?
I can't speak to that case, but I disagree that the legislature could cure an issue to a dedication of a right-of-way that was made 25 years before the state passed the law. And then I do want to note, so it seems like in the briefing it's been taken for granted that in Keokuk Junction, this court was searching out for a statute, and it only came to the conclusion that it did because we didn't happen to have a statute like what Alaska had. I searched on Westlaw, and that Alaska statute has more citations to courts in Iowa than any other state, including Alaska. And if you look at Keokuk Junction, what this court did was say, hey, there's all these different ways different jurisdictions are treating this issue of incidental use by a utility. So let's go through what all of these jurisdictions say about it. And this court only spent 4 sentences on Alaska. And what the court said is Alaska had a statute that dealt with it. We don't have a statute. We're not going to. But the court proceeded then to, in depth, analyze why in Iowa the utility is not an incidental use to a right-of-way. So the legislature adding a statute like Alaska does not necessarily undo what this court has said and analyzed about whether or not a utility is an incidental use to a right-of-way.
Counsel's distinction of Cedar Point, where he says here, the right of exclusion has already been lost. And unlike Cedar Point, the government never had any pre-existing interest in right of entry. How would you answer that?
I believe the second point that I made, that there's 2 issues. If utility usage is not incidental to a road right-of-way, there's absolutely the right to exclude a utility from using that right-of-way. So that's why we can't conflate those 2 analyses. I do want to address another issue, that the language from the IUB on, and I'm not going to get the exact phrase right, but it says, the lack of necessary easements would serve as a basis to deny the franchise. That was absolutely in the order granting the franchise. That wasn't just in addressing a reconsideration motion. That was in the actual grant of the franchise.
Here, what can we infer about the easement, given that it was created in a plat map? And usually we say easements created in plat maps are public dedications. And there is at least some markings on the plat map that indicate a space for utilities, at least as I read it. So what can we infer, if anything, from that? And then what relevance does it have?
I don't think it's teed up for this court to infer anything about the plat map, because that was not appealed. The IUB made the ruling below based on the facts, considering the plat, that there was not a grant of an easement that could be used by a utility company in this case. The IUB looked in depth at, it was Exhibit J5 below, looked at the restrictive covenants, didn't see anything in there in the dedication. The map is insufficient to show that there was an easement that could be used by a utility company here. At most, there showed maybe a 10-foot easement, but what Mid-American is looking for, it's more than 10 feet. I believe it's a 20 to 25 foot. That issue is not cross-appealed to you. And then
I'm looking at the plat map now. It says road right-of-way. My eyes are getting really bad, so forgive me. On the left, it says, overhead electric and underground telephone, right?
An underground tel. And what the IUB said there is, it is unclear, because nothing in the written portions of this dedication say anything about that line, about such an easement. And so if you look at the map, at most what this is saying, maybe it's identifying an existing distribution line, not a transmission line. And so at most it would be a notation of a transmission line or an easement for a transmission line that's within a 10-foot right-of-way, as opposed to a distribution line that's 25 feet out farther into the right-of-way. And we know that also in Iowa, we're not going to expand the scope of an easement. So even if we are going to look at it, this is dedicated to the public, we can't expand that use by just looking at the easement. Thank you. When when we're looking at why the IUB's application of 30646 infects its decision, it's not because the statute on granting franchises says that you need to consider cost. The issue here is that there was essentially a trial below, and that trial was based on evidence, and that evidence only made sense if we're going to say you can use 30646 to go in these right-of-way easements. And if that understanding is wrong, we did not have a fair trial. We did not have Mid-American presenting evidence to the IUB applying the true state of Iowa law. That's why it infects it. It's not because Chapter 478 says otherwise.
Thank you. The case of Juckette versus Iowa Utility Boards and Mid-America Energy is hereby submitted, and the court is adjourned for the day.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.